Hey guys, George here. So we're going to continue our series on the U.S. Constitution. Up next is the Fourth Amendment. Let's get into it. So the Fourth Amendment reads, and I'll read it to you verbatim.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon a probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
So before we get into the Fourth Amendment, let's talk about a little back history. So King George III of Great Britain sent British troops to America to fight in the French and Indian War. Well, the French and Indian War went on a period for almost 10 years and left England pretty much short on cash. King George's solution for this was to tax the colonists. Colonists got nothing in return for it, just basically gave money. So once the taxation began, how did the English know that someone was paying their taxes or not? So to measure this, the English put in an act of writs of assistance. This permitted British soldiers to search whatever they wanted, anywhere they wanted on a whim. The colonists challenged the writs of assistance, being represented by a lawyer named John Otis. Otis argued that the writs of assistance violated the colonists' natural rights. So fast forward to establishing our own government, our founding fathers wanted Americans to be secure and free from unauthorized government search and seizures. The Fourth Amendment is triggered only by actions from the government and only in places where a person can reasonably expect privacy. For example, a public bathroom, one can expect privacy, but a public street, one cannot expect privacy. The amendment covers unreasonable seizures and searches of real property in houses or personal property. A thing is seized when the government takes it. A person is seized when the police agent applies force or makes show of that authority, followed by a submission to that authority. The law is triggered when a physical border is breached, whether that be opening an envelope, a door, or a secured online account. Once triggered, the Fourth Amendment requires reasonableness. It must be reasonable to be constitutional. A reasonable act is accompanied by either a warrant or an exception. For a warrant to be issued, it must be issued with probable cause, which is a logical belief that a crime is being committed, will be committed, based on objective facts and circumstances. Exceptions to this are if you give them your consent or if it's in plain view. There is one more exception, which is called the Terry stop and search. Terry stop search was based on the case of Terry versus Ohio. This is an exception to having a warrant and probable cause. An officer doesn't need to have a warrant under the Terry search, but only a suspicion. And reasonable suspicion is not based on facts. For example, an officer pulls up, you match the description of, let's say, someone who robbed the bank. What's in your bag? That is the Terry stop search. Now, how the Fourth Amendment relates to social media, there is no reasonable expectation of privacy when information is voluntarily shared to a third party or posted on social media. If the Fourth Amendment is violated, it triggers the exclusionary rule. This rule states that illegally obtained information cannot be used against a person whose rights were violated. So they can't use this information against you in a court of law. This incentivizes the police to gather evidence properly. All right, guys, that was the Fourth Amendment. Up next is the Fifth. I plead the Fifth. Explain. Don't miss it.